Pro se legal representation comes from Latin, literally meaning on behalf of themselves, which basically means advocating on one's own behalf before a court, rather than being represented by a lawyer. This may occur in any court proceeding, whether one is the defendant, a plaintiff in civil cases, and when one is a defendant in criminal cases. Pro se is a Latin phrase meaning for oneself or on one's own behalf. This status is sometimes known as propria persona. In England and Wales, the comparable status is that of litigant in person. According to the National Center for State Courts 2006 report, in the United States, many state court systems and the federal courts are experiencing an increasing proportion of pro se litigants. Estimates of the pro se rate of family law overall averaged 67% in California, 73% in Florida's large counties, and 70% in some Wisconsin counties. In San Diego, for example, the number of divorce filings involving at least one pro se litigant rose from 46% in 1992 to 77% in 2000. In Florida, from 66% in 1999 to 73% in 2001. California reports in 2001 that over 50% of family matters filings in custody and visitation are by pro se litigants. In the U.S. federal court system for the year 2013, approximately 27% of civil actions filed, 92% of prisoner petitions and 11% of non-prisoner petitions were filed by pro se litigants. Defendants in political trials tend to participate in the proceedings more than defendants in non-political cases, as they may have greater ability to depart from courtroom norms to speak to political and moral issues. History. The right of a party to a legal action to represent his or her own cause has long been recognized in the United States, and even predates the ratification of the Constitution. The Supreme Court noted that in the federal courts, the right of self-representation has been protected by statute since the beginnings of our nation. Section 35 of the Judiciary Act of 1789, 1 Stat. 73-92, enacted by the First Congress and signed by President Washington one day before the Sixth Amendment was proposed, provided that, in all the courts of the United States, the parties may plead and manage their own causes personally or by the assistance of counsel. In Ferretta v. California, the Supreme Court of the United States held that criminal defendants have a constitutional right to refuse counsel and represent themselves in state criminal proceedings. It said, the right to represent oneself is not absolute. It is the court's right and duty to determine if a particular individual is capable of representing himself, and can inquire into the individual's lucidity and mental status to make that determination. Rules. Most U.S. states have a constitutional provision that either expressly or by interpretation allows an individual to represent one's own cause in the courts of that state. In many instances, state constitutional provisions regarding the right to petition the government for redress of grievances have been so interpreted. The U.S. Judiciary Act, the Code of Conduct for United States Judges, the Federal Rules of Civil Procedure, the Federal Rules of Criminal Procedure, the Federal Rules of Evidence and the Federal Rules of Appellate Procedure address the rights of the self-represented litigant in several places. Section 1654 of Title 28 of the United States Code provides, in all courts of the United States, the parties may plead and conduct their own cases personally or by counsel as by the rules of such courts, respectively, are permitted to manage and conduct causes therein. Laws and organizations charged with regulating judicial conduct may also affect pro se litigants. For example, the State of California Judicial Council has addressed through published materials the need of the judiciary to act in the interests interests of fairness to self-represented litigants. The California rules express a preference for resolution of every case on the merits, even if resolution requires excusing inadvertence by a pro se litigant that would otherwise result in a dismissal. The Judicial Council justifies this position based on the idea that judges are charged with ascertaining the truth, not just playing referee. A lawsuit is not a game where the party with the cleverest lawyer prevails regardless of the merits. Quote, it suggests the court should take whatever measures may be reasonable and necessary to ensure a fair trial, and says there is only one reported case in the U.S. finding a judge's specific accommodations have gone too far. The committee notes to the Federal Rules of Civil Procedure Rule 56 on summary judgments notes that many courts take extra care with pro se litigants, advising them of the need to respond and the risk of losing by summary judgment if an adequate response is not filed, and the court may seek to reassure itself by some examination of the record before granting summary judgment against a pro se litigant. Starting November 1, 2011, the Federal Court for the Central District of California permits pro se litigants to receive documents electronically by an electronic filing account. As of May 16, 2013, they are still prohibited from filing the documents electronically, unlike litigants represented by counsel. The November 1, 2011 policy of the Central District of California is a cost-saving measure for the court. All they have to do is send in the form, have a PACER account, and provide a valid email address. Effective November 24, 2015, amended Local Rules 2.1 and 5.4 of the Federal Court for the Northern District of Florida permit pro se litigants to file and receive their documents electronically by following the same local requirements as licensed attorneys for PACER Next-Gen qualifications and approval for electronic use in particular cases. Order of assigned judge on pro se motion showing pro se's qualifications may be required, and LT, NDFL, U.S. Courts, Gov. Rules and GT, according to a June 2012 report from U.S. Courts. 18 of 94 federal district courts authorize use of ADR for pro ses and 11 authorize use of ADR by prisoner pro ses. 37 of the 94 federal districts allow pro se litigants to use ECF. Limits the ability of a party to proceed without an attorney in prosecuting or defending a civil action is largely a matter of state law, and may vary depending on the court and the positions of the parties. A long-standing and widely practiced rule prohibits corporations from being represented by non-attorneys, consistent with the existence of a corporation as a person separate and distinct from its shareholders, officers and employees. The Wisconsin Supreme Court has ruled that a non-lawyer may not sign and file a notice of appeal on behalf of a corporation. Requiring a lawyer to represent a corporation in filing the notice does not violate the guarantee that any suitor may prosecute or defend a suit. Personally, a corporation is not a natural person and does not fall within the term any suitor. Similarly, a pro se litigant may not act as a class representative in a class action lawsuit, and therefore a pro se litigant may not bring a class action. Furthermore, a non-attorney parent may not appear on behalf of his or her child, except to appeal the denial of Social Security benefits to such child. Another situation in which appearance through counsel is often required is in a case involving the executor or personal administrator of a probate estate. Unless the executor or administrator is himself an attorney, he is not allowed to represent himself in matters other than the probate. Some federal courts of appeals allow unrepresented litigants to argue orally, and in all courts the percentage of cases in which argument occurs is higher for counseled cases. In 2013, the U.S. Supreme Court adopted a rule that all persons arguing orally must be attorneys. Although the Supreme Court claims it was simply codifying a long-standing practice of the court, the last non-attorney to argue orally before the Supreme Court was in 1978. The Connecticut Supreme Court narrowed criminal defendants' right to self-representation, stating that we are free to adopt for mentally ill or mentally incapacitated defendants who wish to represent themselves at trial a competency standard that differs from the standard for determining whether such a defendant is competent to stand trial. A senior assistant state's attorney explained that the new standard essentially allows judges to consider whether the defendants are competent enough to perform the skills needed to defend themselves, including composing questions for voir dire and witnesses. Some courts issue orders against self-representation in civil cases. A court enjoined a former attorney from suing the new lover of her former attorney. The Superior Court of Bergen, New Jersey also issued an order against pro se litigation based on a number of lawsuits that were dismissed and a failure to provide income tax returns in case sanctions might issue. The Superior Court of New Jersey issued an order prohibiting a litigant from filing in federal court. The Third Circuit, however, ruled that a restriction on pro se litigation went too far and that it could not be enforced if a litigant certified that he has new claims that were never before disposed of on the merits. The Tenth Circuit ruled that before imposing filing restrictions, a district court must set forth examples of abusive filings, and that if the district court did not do so, the filing restrictions must be vacated. The District of Columbia Court of Appeals read that private individuals have a constitutional right of access to the courts, that is, the right to sue and defend in the courts. In 2011, the Federal Judicial Conference surveyed federal court clerks' offices regarding pro se issues. They found that only 17 of 62 responding judges report that discovery is taken in most non-prisoner pro se cases, and only 13 reported that discovery is taken in most prisoner pro se cases. In the same survey, 37% of judges found that most pro ses had problems examining witnesses, while 30% found that pro ses had no or few problems examining witnesses. 53% found that represented parties sometimes or frequently take advantage of pro se parties. Only 5% reported problems of pro ses behaving inappropriately at hearings. Respondents to the FJC study did not report any orders against non-prisoner pro se litigation. Some pro se litigants who are federal prisoners are subject to the Prison Litigation Reform Act. The American Civil Liberties Union has asserted, for over 13 years, the Prison Litigation Reform Act has denied access to the courts to countless prisoners who have become victims of abuse, creating a system of injustice that denies redress for prisoners alleging serious abuses, barriers that don't apply to anyone else. It is time for Congress to pass legislation to restore the courts as a needed check on prisoner abuse. 54% of judges responding to a Federal Judicial Conference survey use video conferences for prisoner pro se hearings. In criminal court, pro se representation presents unique but not insurmountable challenges for claimants and the legal system. In Louisiana, for instance, the Louisiana Court of Appeals tracks the results of pro se appeals against represented appeals. In 2000, 7% of writs in civil appeals submitted to the court pro se were granted, compared to 46% of writs submitted by counsel. In criminal cases the ratio is closer. 34% of pro se writs were granted, compared with 45% of writs submitted by counsel. According to Erica J. Hashimoto, an assistant professor at the Georgia School of Law, after conducting an empirical study of pro se felony defendants, I conclude that these defendants are not necessarily either ill-served by the decision to represent themselves or mentally ill. In state court, pro se defendants charged with felonies fared as well as, and arguably significantly better than, the represented counterparts of the 234 pro se defendants for whom an outcome was provided. Just under 50% of them were convicted on any charge. For represented state court defendants, by contrast, a total of 75% were convicted of some charge. Only 26% of the pro se defendants ended up with felony convictions, while 63% of the represented counterparts were convicted of felonies in federal court. The acquittal rate for pro se defendants is virtually identical to the acquittal rate for represented defendants. Quote, "Since an independent evaluation of the cases is difficult, this study can by design not distinguish whether defendants without representation face a greater challenge or whether defendants are more likely to choose representation when in doubt of the merit of the case." In civil court, there is evidence that self-representation is common in civil cases. In New Hampshire, one party is pro se in 85% of all civil cases in the district court and 48% of all civil cases in the Superior Court in 2004. In probate court, both sides are unrepresented by lawyers in 38% of cases. In Superior Court domestic relations cases, almost 70% of cases have one pro se party, while in District Court domestic violence cases, 97% of the cases have one pro se party. One party appeared pro se in California. A study of family matters in 2/3 of all domestic relations cases and in 40% of all child custody cases in 1991 to 95. California reports in 2001 that over 50% of the filings in custody and visitation are by pro se litigants. Urban courts report that approximately 80% of the new divorce filings are filed pro se. In Maricopa County in Arizona, the incidence of pro se litigants doubled in the period between 1980 and 1985. By 1990, 88% of the cases involved at least one pro se litigant, and no lawyers were involved in more than half of the divorces. In Chicago, 30% of all new general civil actions filed for less than $10,000 of damages were filed pro se. Landlord-tenant actions were filed pro se 28% of the time. Utah Judicial Council reports that in 2006, for divorce cases, 49% of petitioners and 81% of respondents are self-represented. For small claims cases, 99% of petitioners and 99% of respondents are self-represented. According to Boston Bar Association Task Force 1998 report, in every court studied by the task force, litigants without lawyers are present in surprising numbers. In some counties, over 75% of the cases in probate and family courts have at least one party unrepresented. In the Northeast Housing Court, over 50% of the landlords and 92% of the tenants appear without lawyers in summary process cases. University of Illinois Law School's Professor Robert Lawless, a national expert in personal credit and bankruptcy, showed that the rate of non-attorney filings in bankruptcy courts by debtors was 13.8% for Chapter 13 cases, and 10.1% for Chapter 7 cases. The rate was as high as 30% to 45% for major urban areas, such as California and New York City. U.S. Bankruptcy Court of Arizona reported 23.14% cases filed pro se in October 2011, up from 20.61% a year before. There are some notable records of pro se litigants winning more than $2,000 as plaintiffs. Robert Kearns, inventor of the intermittent windshield wiper, who won more than $10 million from Ford for patent infringement. Dr. Julio Perez won approximately $5 million in a federal jury trial from Progenics Pharmaceuticals for wrongful termination as a result of whistleblowing. Reginald and Roxana Bailey, a married couple, who together won $140,000 from Allstate Insurance in a federal jury trial. George M. Cofield, a pro se janitor, won $30,000 from the city of Atlanta in 1980, and Jonathan Odom, a pro se prisoner, who while still a prisoner, won $19,999 from the state of New York in a jury trial. Timothy Allen Albertson, who appeared in pro per, was awarded $3,500 in 1981 in a judgment by the San Francisco Municipal Court entered against the Universal Life Church for defamation by one of its ministers. Reasons. According to the 1996 report on pro se by University of Maryland Law School, 57% of pro se said they could not afford a lawyer. 18% said they did not wish to spend the money to hire a lawyer. 21% said they believed that their case was simple and therefore they did not need an attorney. Also, a legal needs study shows that 45% of pro se believe that lawyers are more concerned with their own self-promotion than their client's best interest. Defendants who choose to appear pro se may do so because they believe they may gain tactical advantages against the prosecutor, such as obtaining sympathy from the jury, the opportunity to personally address the jury and witnesses. Pro se appearances may also delay the trial proceedings and enhance the possibility of a mistrial and a subsequent appeal. Once a prisoner has been convicted, they don't have a right to a public defender. Motions for post-conviction relief are considered civil motions. Brandon Moon is an example of an unsuccessful pro se litigant who became successful when his case was taken by a lawyer. Moon's case was taken by the Innocence Project, which doesn't take very many cases. He was released after 17 years in jail for a rape that he didn't commit. Before he was able to interest the Innocence Project in his case, he applied many times and made the same arguments that the lawyers later won with. The New York Times reported this in an article on December 22, 2000 as an example of courts not paying attention to pleadings by pro se litigants. Self-representation by attorneys. An attorney who represents himself or herself in a matter is still considered a pro se litigant. Self-representation by attorneys has frequently been the subject of criticism, disapproval, or satire, with the most famous pronouncement on the issue being British poet Samuel Johnson's aphorism that the attorney who represents himself in court has a fool for a client. Attorney fees. The Supreme Court has held that where a statute permits attorneys' fees to be awarded to the prevailing party, the attorney who prevails in a case brought under a federal statute as a pro se litigant is not entitled to an award of attorneys' fees. This ruling was based on the court's determination that such statutes contemplate an attorney-client relationship between the party and the attorney prosecuting or defending the case, and that Congress intends to encourage litigants to seek the advice of a competent and detached third party. As the court noted, the various circuit courts had previously agreed in various rulings that a pro se litigant who is not a lawyer is not entitled to attorneys' fees. Narrow exceptions to this principle have also been suggested by other courts in the United States. For example, according to one district court, a state-licensed attorney who was acting as pro se may collect attorney's fees when he represents a class in a class action lawsuit, or according to another court represents a law firm of which he is a member. In each of those instances, a non-attorney would be barred from conducting the representation altogether. One district court found that this policy does not prevent a pro se attorney from recovering fees paid for consultations with outside counsel. Pro se who are not state-licensed attorneys cannot bring up a class action lawsuit. Federal courts can impose liability for the prevailing party's attorney fees to the losing party if the judge considers the case frivolous or for purpose of harassment, even when the case was voluntarily dismissed. In the case of Fox v. Vice, U.S. Supreme Court held that reasonable attorney's fees could be awarded to the defendant under 42 U.S.C. Sec. 1988, but only for costs that the defendant would not have incurred, but for the frivolous claims, unless there is an actual trial or judgment. If there is only pre-trial motion practice such as motions to dismiss, attorney fee shifting can only be awarded under FRCP Rule 11, and it requires that the opposing party file a motion for sanctions and that the court issue an order identifying the sanctioned conduct and the basis for the sanction. Pro se still has a right to appeal any order for sanctions in the higher court. In the state courts, however, each party is generally responsible only for its own attorney fees, with certain exceptions. Notable pro se litigants. Despite the presence of 5 court-appointed attorneys, serial killer Ted Bundy would make high-profile pro se appearances in his Florida murder trial beginning in June 1979. The trial was covered by 250 reporters from 5 continents, and was the first to be televised nationally in the United States. Edward C. Lawson, an African-American civil rights activist, was the pro se defendant in Colenda v. Lawson, in which the U.S. Supreme Court ruled that a police officer could not arrest a citizen merely for refusing to present identification. Robert Kuntz was the inventor of the intermittent windshield wipers. He acted as his own lawyer in parts of his long legal battles for patent infringement against Ford and Chrysler. His legal battles are the subject of the 2008 film Flash of Genius. Dr. Julio Perez was a chemist at Progenics Pharmaceuticals who represented himself as a pro se plaintiff at a jury trial for a civil suit 10 CVO 8278 in the Southern District of New York in July 2015. As a wrongfully terminated whistleblower, Perez won $1,662,951 in back pay, and in August 2016, the presiding judge at Perez's trial against Progenics, the Hon. Loretta A. Preska, awarded Perez an additional $2,706,585 in front pay for 8 years until Perez's projected retirement at the age of 66 years and 6 months, plus $613,277 in accrued prejudgment interest from Perez's firing in 2008. Perez received front pay in lieu of reinstatement to his previous position at Progenics. Clarence L. Gideon was too poor to afford an attorney and thus proceeded pro se in his criminal trial in Florida in 1961. He was found guilty and subsequently appealed. He was appointed counsel when the case reached the U. Supreme Court. The court ruled in Gideon v. Wainwright that the right to counsel means that states are required to provide counsel free of charge to indigent defendants in all criminal cases, and that Florida's failure to appoint such counsel in Gideon's case constituted a violation of the right. On remand, Gideon was represented in the new trial, and was acquitted. Jim Traficant, a former U.S. representative from Ohio, represented himself in a Racketeer-Influenced and Corrupt Organizations Act case in 1983, and was acquitted of all charges. Traficant would represent himself again in 2002, this time unsuccessfully, and was sentenced to prison for 8 years for taking bribes, filing false tax returns, and racketeering.